Hello viewers, this is me Dr. Sanyogita, Assistant Professor, Himachal Pradesh University, Shimla. Today I am going to discuss the topic comparative study between civil law and common law. First of all, introduction of the topic. Every nation is governed by its own legal system, which sets the framework for how citizens should conduct themselves. There are approximately 200 countries worldwide, and each has developed a legal system shaped by its unique characteristics and cultural factors. These systems of laws and rules guide societal behavior and help define moral standards within the community. Globally, legal systems are broadly categorized into two main types, common law and civil law. Around 120 countries follow predominantly civil law systems, while roughly 80 nations operate under common law systems. Now, understanding civil law. Civil law, as explained by renowned jurist John Salmond, refers to the law of the state or the law of the land, the law of lawyers and the law of courts. The term originates from the Latin jus civile, meaning law of citizens, which was initially used in ancient Rome to describe the laws applicable to its citizens. Civil law is also referred to as the Romano-Germanic law and is often codified, meaning it is written down in comprehensive legal codes. This legal system is structured with clarity, featuring well-organized codes that are designed to be easily accessible to both citizens and legal professionals. Civil law systems are rooted in Roman law principles and aim for cooperation, order and predictability. They are also adaptable with general provisions in the codes that allow for flexibility and adjustment over time, avoiding excessive detail while still ensuring a broad and cohesive legal framework. Civil law traces its origins to Roman law, particularly the Corpus Juris Civilis, compiled under Emperor Justinian. Over time, this legal framework influenced the development of civil law systems in continental Europe and beyond. The core characteristic of civil law is its codification in comprehensive civil codes. These codes are often described as systematic, authoritative, and guiding statutes of broad scope, ushering in reforms and making a new era for a nation's legal system. Notable civil codes were introduced in the 19th and 20th centuries, including French Code 1804, Austrian Code 1811, German Code 1896, Japanese Code 1896, Swiss Code 1907 and Italian Code 1942. These are typically categorized into the Romanic and Germanic legal families. While civil codes from different countries are not identical, they share certain core features that distinguish them from legal systems based on other traditions. One defining trait of civil law is its structured, classified nature, with many general principles and rules that guide legal practice. A central tenet of civil law is that courts primarily apply and interpret the law as outlined in the code of statutes to the facts of individual cases. The assumption is that the code should cover all potential scenarios, and where it does not, courts are expected to fill in the gaps using general legal principles. On the other hand, common law is a legal system where the law evolves through court decisions rather than being codified in statutes or passed by a legislature. This system is prominent in countries such as United States, the United Kingdom, Canada, and other former British colonies. In common law systems, judicial decisions in specific cases set precedents that influence future rulings. Historically, English common law began with issuance of formal orders known as writs by the Crown. These writs formed the foundation of common law systems. Over time, equity courts were established to handle cases that the writs could not adequately address, creating remedies based on principles derived from various sources, including Roman law and natural law. As common law developed, court used precedents to guide their decisions, adapting past rulings to meet contemporary needs. This process laid the groundwork for the modern common law system. Common law has four main characteristics that distinguish it from the other legal systems. Precedent. Courts are bound by previous rulings in similar cases, which ensures consistency and predictability in legal decisions. Case law. Legal rules and principles emerge from the outcomes of the individual legal disputes rather than from formal statutes or written codes. Judicial interpretation. Judges have a pivotal role in shaping the law. They interpret existing statutes, apply principles of fairness, and resolve ambiguities within the law. Flexibility. Common law can evolve and adapt over time through new interpretations or rulings by the courts, reflecting changes in the society. Unlike civil law systems, which are based on detailed written codes, common law is primarily shaped by judicial decisions and case law. Common law originated in England around the 11th century and later spread to countries such as the United States, Canada, Australia, New Zealand, and other nations within the British Commonwealth. The most significant difference between civil law and common law systems is that civil law is codified and based on comprehensive legal codes, while common law develops through judicial decisions rather than legislation. The core principle of common law is that decision made in previous similar cases, especially those by higher courts, should guide the outcome of current cases. This principle is known as stare decisis. While not a written law, stare decisis is respected and followed by courts, which may choose to modify it when necessary. The primary distinction between common law and civil law systems lies in their sources of law. In common law, countries' case law derived from published court rulings holds significant weight. In contrast, civil law systems are centered on codified statutes with written legislation taking precedence. However, these distinctions are not always as clear-cut as they may seem, as many countries incorporate elements from both legal systems. The origins of civil and common law systems trace back to different historical roots. Civil law finds its foundation in Roman law, specifically the Corpus Juris Civilis, compiled under Emperor Justinian. This legal tradition has influenced the development of civil law systems in many countries, particularly in the continental Europe. In civil law jurisdictions, the primary source of law is the civil code, which is the comprehensive authoritative statute that provides a detailed framework for legal matters. Most civil codes were adopted in the 19th and 20th centuries, including the French Civil Code 1804, Austrian Civil Code 1811, German Civil Code 1896 and others such as Japanese MIMPO 1896, the Swiss Code 1907 and Italian Civil Code 1942. These codes, though differing in some aspects, are often classified into Romanic or Germanic families, reflecting their historical roots and legal principles. While the civil codes of different countries may vary, they share certain defining characteristics. Civil law countries, many of which were former colonies of France, Spain, Germany, Netherlands, Portugal, predominantly follow the civil law tradition. This includes much of Central and South America as well as various countries in the Central and Eastern Europe and East Asia. In France, for example, the legal system is based on a civil law framework where legislation is codified and takes precedence over judicial decisions. In these systems, the principle of stare decisis, the doctrine of precedent, does not apply in the same way as in the common law systems. Instead, each case is decided based on how it aligns with the codified law, and judges interpret the statutes accordingly. This means that similar cases may have different outcomes depending on the judge's interpretation of the law. Germany operates under a federal system with the basic law serving as the nation's constitution, supplemented by individual state constitutions. However, federal law generally takes precedence over state law. Japan's legal system, also a civil law system, is built around codified statutes with the constitution and 5 major codes: civil, civil procedure, criminal, criminal procedure and commercial. forming the core of its legal structure. In China, civil law plays a crucial role in governing personal and property relationships and serves as the foundation for a wide range of special laws and economic regulations within the country's legal framework. The development of English common law can be traced back to the Middle Ages, when the centralizing power of the monarchy began to take shape. Following the Norman conquest, English kings started consolidating authority, establishing new institutions to uphold royal justice and governance. One of the earliest legal innovations was the creation of a system of writs, royal orders, that provided specific remedies for distinct wrongs. However, over the time, the writ system became so rigid and formalized that it often failed to deliver true justice. In such cases, people had to seek the king's intervention directly to resolve the legal matters. This limitation in the legal system led to the creation of new court known as Court of Equity or the Court of Chancery, which was presided over by King's Chancellor. Courts of equity had the authority to apply principles of fairness derived from various sources like Roman law and natural law, rather than strictly adhering to the rigid rules of common law. This allowed courts of equity to deliver more just outcomes in cases where the common law was inadequate. The separation between courts of law and courts of equity persisted until the mid-19th century, when the writ system was abolished. But in some parts of United States, courts of equity still exist. Similarly, certain writs like the writ of habeas corpus remain integral to modern legal practices. The writ of habeas corpus, for example, continues to play a significant role in protecting individuals from unlawful detention. Originally, it was a royal order issued by the king, either at the request of a prisoner or on their behalf, that summoned the prisoner to court to verify whether their detention was lawful. This legal mechanism emerged during the same period that the Magna Carta was signed in 1215, which established key individual rights, including the principle that no free man could be imprisoned or punished without a trial by a jury of their peers, thus guaranteeing the right to a jury trial. During the Middle Ages, English common law coexisted with other legal systems, including canon law applied by church courts, customary law used in urban and rural courts, and Roman law followed in chancery and maritime courts. It was not until the 17th century, however, that common law firmly established itself as the dominant legal system. This shift occurred when Parliament, having asserted its authority over the English monarchy, claimed the power to define the common law and declared all other laws subordinate to it. This period marked a crucial turning point, as England's development of a national legal system mirrored similar efforts in civil law countries during the early modern period. When we compare civil law and common law, we observe that they arise from two distinct legal philosophies and approaches to the law. In the civil law system, The core principle and rules are primarily found in codified statutes and codes. These legal codes are comprehensive and serve as the foundations of the legal system. Courts in civil law jurisdictions apply these pre-existing laws to specific cases, meaning statutes take precedence over case law, which serves as a secondary source. Civil law is built around the idea of separation of powers, where lawmakers create the laws and the judiciary's role is to interpret and apply them. In contrast, common law is largely shaped by judicial decisions. Over time, the rulings in individual cases accumulate and form a body of law. Common law lacks the rigid structure found in civil law, relying instead on past court decisions to guide future ones. This system evolves through precedents set by judges, and there is less reliance on comprehensive codes or statutes. In common law countries, courts play a primary role in shaping the law, as judges interpret and expand upon legal principles in response to cases brought before them. One key difference is the approach to legal reasoning. In civil law, lawyers typically begin by referencing the codified legal rules and using deduction to apply these rules to specific cases. On the other hand, lawyers in common law systems often start with the facts of the case and compare them to prior rulings or precedents to derive legal principles inductively. As a result, lawyers in the civil law systems tend to be more conceptual and structured in their thinking, whereas those in common law systems are more pragmatic, focusing on case-specific analysis. To summarize the main differences, approach to the legal process, civil law is based on written codes and statutes, while common law is based on judicial decisions and precedents. Role of legislators. In civil law systems, legislators are responsible for making law and courts apply it. In contrast, courts in common law systems have a more active role in shaping the law through their rulings. Thirdly, lawyers' approach to the case. Civil law is based on comprehensive codes that present a structured hierarchy of concepts, starting from broad principles and narrowing down to a specific rules. A civil lawyer typically starts by consulting the legislation to identify the applicable legal standard and then applies logical reasoning to the particular case at hand. In contrast, a lawyer in the common law system begins with the detail of the specific case, seeking parallels with the past decisions and drawing conclusions based on relevant precedents. This fundamental difference in approach means that civil law attorneys are often seen as more theoretical and deductive, whereas common law lawyers are more pragmatic, focusing on practical case-by-case analysis. Fourth, the binding force of precedents. In civil law, courts are primarily tasked with resolving disputes by applying and interpreting existing legal norms. Their role is to make judgments on specific cases without necessarily setting broader guidelines for future cases. In contrast, common law courts do not just resolve individual cases, they also establish precedents that guide future decisions. In the common law system, decisions made by higher courts are binding on lower courts, meaning that the interpretation of laws in the particular case can influence how future cases are handled. Role of lawyers and judges in each system. In civil law countries, judges are often described as investigators because they take an active role in leading the proceedings. They may initiate investigations, gather evidence, examine witnesses, and apply solutions derived from the legal code. In this system, lawyers primarily represent their clients, but their role is somewhat secondary compared to that of the judge. On the other hand, in common law countries, lawyers play a more prominent role in courtroom. They advise clients, prepare legal documents, and actively participate in court hearings by presenting arguments and questioning witnesses. In some common law systems, such as United States, only licensed lawyers are allowed to draft legal documents for others. Unlike in a civil law system, where non-lawyers may perform such tasks. The importance of oral advocacy and courtroom presentations is less in civil law countries compared to common law systems, where lawyers have more latitude to actively engage in the trial process. In common law countries, attorneys often serve as primary representatives in court, advocating on both legal and factual matters, with the judge playing a more moderating role. This is in contrast to civil law systems, where the judge typically has more control over the investigation and application of the law. In the conclusion, we can say, as the globalization continues to influence legal systems worldwide, the differences between common law and civil law are becoming less pronounced. Ultimately, the choice between the two systems is not about one being superior to the other, but about how each system meets unique legal, social, and economic needs of the societies they serve. Both systems have proven to be effective in delivering justice and have adapted over time to the demands of their respective environments. This is all for today's lecture. See you in the next lecture with new topic. Till then, thank you. Goodbye.